Is the
Look like
chair?
he's answering a phone. He said, "How are you?" So I don't know what is happening.
evidence by General Masemola and General Mkhwanazi. The ANC.
Thank you very much, Chairperson. We find no fault with the letter of the President. I think the request that they submit their responses on the 6th of March is acceptable, so we have no problem with that. On the process that has just been outlined, Chair, I'm not sure if it should be read together with the framework document that had been circulated to us before, because that framework document, I think, was more or less saying the same thing. We just had a question that arose from the framework document where it said, and I suppose the question arises again now, that the document, it says findings, it will make findings which differ from what the initial document said, that it will make no findings of wrongdoing and so forth and so forth. I just don't have the right phrasing in front of me now. I think we need clarity on what we mean by findings, given the fact that some of the evidence would be in dispute. What mechanisms would we be using to test which of the evidence is accepted? I don't know what the legal terminology for it should be, but we just want to get a sense of how do we come to certain conclusions on matters where some of these evidentiary gaps do exist. How is the committee going to handle that? But insofar as process is concerned, Chair, we have no issues with the process. Thank you very much.
Thank you. Ms. Silkstone, are you able to clarify the question that is being posted?
Yes. Well, I can try. I think that we need two things. The first is just to say that in terms of the discussion paper that the content team will put together, when I talk about we won't make findings, or what we're talking is we won't make findings as to the evidence. So if we say witness X said Y, we won't say, well, witness X is guilty of. That would be, we don't have the authority. That's completely out of our thing. But in terms of what the content paper does is that, we feel comfortable with like looking at, say, governance concerns. So it's clear that looking at the evidence, this is an example. I'm not saying that this is necessarily clear, looking at the evidence that there is a problem of communication between this agency and that agency. So if does that kind of, I hope that sort of assists in terms of where we are. In terms of what evidence and how the committee should accept evidence, I think that's something that our legal team should advise the committee on, because the evidence is contradictory. We have many hours of witnesses saying things, and putting all of that together is, it is difficult. Thank you. I hope that assisted.
So what you are essentially saying is that the committee does not pronounce on the guilt or the innocence of a witness.
I mean, that is for the committee to decide, but that would need to be advised by legal. I'm just saying that from the content team's perspective, in our discussion paper, we won't be making those kinds of kind of analysis.
Listen to what I'm saying. The committee is in the main investigating 4 pillars in the terms of reference. And committee members want to know if we must separate between issues. Where the committee, for instance, finds that indeed the decision to disband the PKTT was unlawful. Are you saying the committee can't make such a finding to say the decision was unlawful?
No, that's not what I'm saying at all. I'm
Okay,
no, that's not what I'm saying.
you are saying such findings can be made, but on the criminal part of allegations that would have been made against certain witnesses, the committee doesn't have judicial competence.
Precisely, Chair. So in your first example,
Yeah.
say, on the unlawful, yes, precisely.
Yeah.
On the unlawful things, you would obviously give your reasons, but yes, you wouldn't be able to pronounce on innocence or guilt.
Because when you arrive at the innocence or guilt of a witness, obviously you must follow the Criminal Procedure Act or any other relevant legislation, and you must also be consistent with the Constitution when it says a judicial authority in this country is vested with the judicial. So a committee of parliament cannot pronounce on the innocence or the guilt of a witness, but a committee can make findings which do not concern themselves. For instance, if the committee makes a finding that a wrong has happened, and the committee can further recommend that because it does not have those powers to pronounce guilt or innocence, the matter can be referred to the relevant authorities for further processing.
Yes, Chair. The committee can make observations and make recommendations.
Yeah, that's exactly what I think what Honorable Sangweni wanted to understand, so that it must not just be a nebulous statement that says the committee can make findings, and it ends up restricting members in terms of understanding what they should do.
No, I apologize if there was any confusion. Of course, the committee can make findings and observations, but it's just about we can't step into the arena of being a court of law because we don't have that authority and we don't actually have, that's so. Just understanding it can be a bit tricky, but it's also about how you phrase your findings and you phrase your recommendations, and as long as there's also a very clear link between the evidence that you're using to support whatever finding that you make, so that it's that rationality component is dealt with.
Okay. Honorable Sangweni, are you clarified?
Yes, Chair, I'm clarified, although I suspect that the boundaries, we'll probably have to keep going back to them, and it may be useful if, we could just get, I don't want to ask for additional opinions or anything, but almost, how far our powers as Parliament go, Chair, in relation into this matter. Because I don't want, when we are now discussing the matter, we get drawn into a temptation of overstepping our boundaries, and then people are accused of either protecting, not protecting. We just need to be very clear in terms of what our boundaries are, so we all operate within that framework. And lastly, Chair, whether anybody who has an adverse observation made about them in the report, they will be afforded an opportunity to comment before the report is finally put before the National Assembly it's tabled before the National Assembly. Thank you, Chair.
Okay. The MKP.
Thank you, Chair. Before Honorable Nomvalo comes in, I just wanted to say Chair, if I may ask, the lady who was speaking here, is she the chief, is the chief legal advisor we started with, or is somebody else?
No, she is part of the content team, the team that will be writing the report for the committee.
So where's the chief legal in the is she here?
Mr. Dajana is present in the meeting.
Yeah, no, Mr. John, I understand. Remember, we had the chief legal. There was a lady who was the chief legal who I asked many times that, yeah.
She's no longer with Parliament.
Oh, we've got the new chief legal advisor now.
She's on retirement.
Oh, so we've got a new chief legal advisor.
That I may not know.
Yeah, I think the legal team was supposed to tell us about these stories as well, because we were told about a chief legal advice most of the time, and if they are quiet, I think they have to tell us about whether, because now the issue of innocent, we can't say somebody innocent, we can't say somebody is guilty, but I think we can make recommendations, Chair, to say this evidence is substantiated, and we recommend what must happen. Then the rest, obviously, the Parliament will take the decision on that. But we can't do so much job, and then at the end we cannot pronounce anything. It's like now we were just ticking the boxes here. We have to say it. If somebody, for instance, Mr. Honorable Soviet Nhlanhla, the evidence against him is substantiated, and we recommend that the following must be taken. You've broken this act, section so and so, and yes, but we must substantiate that to say if the evidence is substantiated, we must do that. But we can't just say we are mum. We can't say anything. But I leave it to the legal expert. We've got Honorable Nomval. I think he'll come in, Chair. Thank you.
Then,
yeah, thank you, sir.
Before, what is your view, Honorable Skwasana, on the letter from the President and
I left it for Honorable Nomvalo, Chair.
Yeah, but there are two matters which were circulating. The one is that the team must now go back and develop a checklist of activities that will be happening after the presentation of evidence. Do you agree with that?
No, Chair, hence I'm saying to you, because I heard you most of the time on the deliberation, asking the lady about, we can't say somebody, hence I only focus on that. And Honorable Nomvalo will respond on those two items. Thank you, Chair.
Okay, thank you. Honorable Nomvalo.
Yeah, no, thanks, Chair. I think we threw some comfort on how you've concluded with the I don't know whether it's a legal advisor or what, but with the lady who was advising us, because initially we were not comfortable because of the ambiguity. I think the advice was a bit vague, because our understanding, Chair, is that we will firstly, we'll analyze evidence that we have obtained, and vis-a-vis, we'll cross-reference to the testimonies that have been given, both orally and in writing, and make findings to say, based on this evidence, this is what we have found to have transpired. And based on this finding, this is what we recommend. So that is our understanding, even though a concern which has always been raised by Honorable Mates keeps on kicking in and is going to catch up with us, because under normal circumstances where you have done a thorough investigation, you make recommendations and submit prima facie evidence that you have obtained through your skills to the relevant authorities. For instance, when you recommend to the police, say you have identified an act of criminality, at least give them something to say, here you can investigate further. This is what we have found, and you can use this information to initiate your investigation. So, what Honorable Mateus has been raising will catch up with us because largely we will submit just a written report to say we've analyzed evidence and so on, but with no material evidence, with no tangible evidence that will back up our report. So that remains our great concern because we believe that there are many matters by virtue of their nature which we should have taken further in terms of investigation, Chairperson. Many, I can mention many, but we have not done so because our capacity was very limited. We didn't investigate further, except relying on oral evidence. The tender, how it was issued, the documents, to get the documents of all these committees that sit before the appointments, the bid evaluation, the bid adjudication. We didn't take further the matter of Kumalo in terms of investigation, the appointment, because there were allegations that he acted wrongly by employing people not following the procedure and so on. Many issues have not been taken further. We did not even have capacity of tracking devices. So that is a shortcoming that we must be alive to say when we complete our work, we must know that we have only done 10% of what we were supposed to do because we had limited resources. So I guess now it's late. There's nothing we can do. But I really wish that we should have taken what Honorable Mateus has been crying for since day one. We didn't want to repeat what she had already said because it was making sense to all of us. So we thought it's going to prevail to all of us. But now it will catch up with us. With regards to responses, Chair, by the President, well, we even though we disagree, we never agreed and we still disagree, but because we're in a democratic institution here, we subject ourselves to the behest of the majority despite our strong sentiments on the subject. We said that we don't agree with writing questions to the president because we don't want to give a special treatment to anybody. Everyone must be treated equally because here we're not doing a normal oversight process. We're doing an investigation. So we've limited ourselves because we're asking a person here to whom we're not going to have an opportunity for follow-up questions, an opportunity to interject when there's a need to do so, like we have done with other witnesses. So a special treatment on the basis that he is the president. So, like, we're not taking this excuse of the 16th because, yeah, everyone is complaining about time, but the president is not complying with time. The 16th is too far, Chairperson. The responses must be given now because if there are questions that have not been answered satisfactorily, we believe that we must be given an opportunity again for follow-up questions. Now, if the president responds when we're about to finish, then that means we're not going to have that opportunity. We're hoping, Chair, that because we've done the work of the president to be easy, we've simplified his task by saying, just respond even when you are lying in your bed at home. We thought he's going to take advantage of that and give us a report on time, swiftly, within the twinkling of an eye. Now we're told that the report will be ready on the 16th. So we're not accepting that, Chair. Thank you.
The DA.
Thank you, Chairperson. Chairperson, the position of the Democratic Alliance that I think the committee must just remain faithful to what the mandate was, and it's parliamentary oversight. And we're not a court of law, Chairperson, so we can't determine criminal guilt. I think our responsibility is to assess the testimonies that were presented, as well as the evidence that was placed before us, and make the observations and findings based on that material, and not determine guilt. And where the evidence does present that there was possible misconduct or that further disciplinary action should be taken, well, then that is what we should be reporting on. So we're not there to prosecute, we're not there to adjudicate, and we just ensured that the credible issues that got revealed through this process of this inquiry do not just disappear. And I think that referring them to the relevant authorities to further investigate and prosecute where they deem fit is the route to take. I think one of the core mandates was to identify what weaknesses were in our institution. That is what our core mandate wasn't to find guilt in a specific person, but understand where the institution allowed that misconduct, corruption, interference, whatever it was that occurred, is to understand how the institution was affected by that. And I think that is some things that have to be highlighted within that report so that we can make those amendments, legislative changes, and see how do we fix the institutions that were either infiltrated or where procurement was done underhandedly, where tenders got out without following proper procedures. And I think one of the very important things is how communication left institutions meant to be, private and internal, and made its way into the likes of certain individuals who are now, facing criminal charges already. The objective of the work, I suppose, then just comes down to, we need to keep it factual, and it must arise from the evidence. And second, the institution is responsible for upholding the rule of law, Chairperson. And I think that is what our recommendations must speak to, is closing those gaps that we have identified. And we need to go, or at least, the evidence leader with our legal team need to go through, what evidence has been placed, how does it of these various gaps, and makes recommendations to the committee that can then go to Parliament to be tabled. Chairperson, that's my position on that. And as far as what the President's letter is, it is what it is. We do need to receive it, and hopefully quicker than later. Thank you, Chair.
And then on the letter from the Presidency.
I agree that it can come when it comes, Chair.
Thank you so much, the EFF.
Chair, thank you. On the issue on what we are dealing with now about what our final report, what we are allowed to do and what we're not allowed to do in the final report, I would suggest that we actually maybe perhaps have a half-a-day workshop or whatever needs to be done on what our legal obligations are in terms of the Constitution, the Powers and Privileges Act. So when we start that process, we are well informed, we are able to ask questions. I also think political parties should consult independently, because right now it feels like we are being misguided or possibly misguided into what it is, what findings we can make. Chair, it can't be that we are here and this committee is only here to decide whether there was some institutional, where there are gaps in our institutions and how to fix it. If there is evidence before us that I awarded a tender illegally or unprocedurally, that is a finding, and we should be able to make it, not go and just say, okay, this procedure within the act of awarding a tender was breached, and then let's go and see how we're going to fix it. That's not what our terms of reference has allowed us to do. But having said that, I think we must allocate today where we are properly workshopped and we are all on the same page, and it must be done in front of the entire country. So when we are going into deliberations, the entire country can see the members of parliament and what their positions are in dealing with this matter. Having said that, Chair, I think we must also just get on the President Ramaphosa's response. We are concerned with the time. From what I remember is that we agreed that we would get written responses, and based on that, we will make a decision on whether President Ramaphosa will appear before us physically. So once we push that date back, we are also opening up ourselves to a possibility that after we get the responses, and actually we shouldn't call them responses, it must be answers, because again we will get things that are not answering our questions, and we must have recourse as a committee to be able to get answers that are actually answering the question. So as long as the committee is cognitive that the final submission or the response that the president gives us on that day is not the end of it, and we're going to go into deliberations with that information without having an option of getting clarity and understanding exactly what it is, we can support that, and the committee must know what it is also opening itself up to. I also would have liked to know, and then maybe this will come up when we have, if we decide to have sort of a mini workshop on what it is that we have. The discussion document, I would have thought by now. So as the EFF, we submitted all since these committees, our proceedings started, anything or questions or background of things or evidence that we need from institutions. So I would have thought that perhaps even in the discussion documents, that those that are leading that perhaps they can highlight and say, if we get evidence or if we get a letter from, let's just say, the Auditor General that confirms or states what this witness says. Remember, we have access to every single institution. They can't lie to us, and that will be able to assist us in our process. We cannot go into deliberations, and it can never be intentional that we as committee members can make a decision to go into deliberations without being able to say, let's get information from this institution, and we just say that we can't decide because we have two, let's say, statements that are different, when we can go to, let's say, the AG and say, okay, on this day did this happen. So that is something what we must be able to do. And Chair, that brings us right back to the point that we have, this committee has been deliberately, and now we're at the end, has been deliberately denied resources that were in the tabs of reference, so we can be in this position. So when we go into deliberations, and it's another sad thing that we must be alive to, we go into deliberations and we are unable to make concrete findings because we have been denied the resources. And Honorable Nombalo, we must be clear, we mustn't say we lack resources. It was deliberate. Those things are in our terms of reference. It is here in Parliament where budgets are approved. How is it that Parliament cannot provide resources to a committee, Chair, that is investigating this or trying to establish what is it in our criminal justice system that makes us unable to even process rapes of children in this country? And we have been denied that. And now we are here. So, Chair, I'm pressing on this committee right now that you, as the Chair, go and engage the Speaker. And now we're probably going to need more than one forensic with whatever information that we need. And that would come up from the discussion documents, or where there are gaps in evidence. We must be able to answer. Honorable Sangoni brought that up. There are going to be gaps. What is it that we need to close the gaps? Because it cannot be that we have spent so much time and so much energy on this committee for the nation. The nation has been watching this. Some have called us clowns, but at the end of the day, we still need to complete this and do it efficiently. And we must hold our institution itself accountable for not providing us with resources. And now they're going to have to come to the party, and wherever there are evidence gaps, we must be able to get forensic investigators or whatever it is that we need to be able to fill those gaps as much as possible. Thank you, Chair.
the ISP.
Thank you, Honorable Chairperson. On the submission of the President, the 16th of March, well, even though one would have appreciated an earlier date, but we will be able to actually receive that information on the day stipulated by the President's office. But if there is anything that can be done to expedite that, it would be appreciated, because as Honorable Nomvalo has indicated, that there might be a need for, further clarity seeking questions on the response of the President. Now, there would be no sufficient time to actually engage into that. With regard to the second matter, I think I want to go along with the proposal made by Honorable Matthys, that perhaps before we engage in the process, we sort of have some kind of a workshop of some sort to actually the brainstorm on other issues, so that we know exactly the boundaries that exist on what we can and cannot actually say in our report. But I do want also to express a concern that there are some evidence that we actually have received from some witnesses, which actually leaves much to be desired. And some of them actually contain elements of outright, lying. I don't know, in situations like that, what is it? How do you put that in the report, other than to say that, witness X actually presented, a testimony which had serious gaps on certain instances, which might actually lead us to a particular finding on the weight of that particular evidence. So on that score alone, I think it would be very useful for the committee to go through that kind of workshop by some legal experts, so that we know exactly what to do, what not to do. Thank you.
Honorable Sauls.
Chairperson, thank you. I think, firstly, it's important that we take serious the lack of trust that the public has in our institutions, including ours. And we must restore that trust in our processes. And one of the ways we can do that is by how we do this report. Because there's a general sentiment amongst South Africans that nothing's going to happen after this. This is just a show, it's just theater, it's just theatrics. Nothing's going to happen. So our country is crying out for justice, they're crying out for action. And we should ask ourselves, what does the Constitution empower us to do to ensure through our report that there is action? That should be our question. Yes, we are not a court, indeed, but we are a constitutional oversight body. And the Constitution gives us the power to demand, not request, demand accountability. And I feel that this must come through in our report. We must use oversight language. We mustn't use, we must use mandatory language, for the lack of a better word. We mustn't say, mustn't come across as it's optional. We must come across as our language must be directive. We must avoid words like the committee suggests or the department should consider. We should be directive in our approach. Say the committee directs that, or the committee mandates that. The executive must, because that's oversight. That's constitutional authority that's given to us to do so. Yeah, we don't deal with evidence in terms of what the courts does, but we can establish prima facie evidence. We can say on the face of it, these are prima facie violations that we've discovered through our process. So instead of pronouncing guilt, we state that the evidence gathered on crimes such as fraud or contraventions of the PFMA or whatever, we've established prima facie evidence to that. And then the legal institutions that are responsible for investigations can then take that on the face of it and dig deeper. Are we correct? So this creates then some sort of a legal handover point for the police. They have some place to start from. And then we demand accountability. We track the progress around that. Our report must be an evidence file. You see, where we provide information and we point you to the proof or the evidentiary documents that we've received during our processes. And this makes, the report sort of trial ready for the NPA. We must use that approach. And then we must set hard deadlines for feedback. You see, every recommendation must be tied to a time frame. And that's my submission, Chair, to say we must ask ourselves, what can we do that's action driven to make this report be action driven? This report must have oversight language to pull action from the institutions and the agencies, so that our country then can see that the work that we've done was in order to bring justice, not just to suggest things and people can just use it as a file there, they put it aside. And then we must also not just give our report to the speaker and the speaker to the president, whoever. We must also have a formal resolution that our report must be an evidentiary file that we give to the NPA, or we give to or we give to crime intelligence. Say, here's prima facie evidence that you can use for investigations into this matter. I think in that way, we have done our best based on our constitutional function to assist the process of justice. Thank you, Chair.
Honorable Vessels.
Thank you, Chairperson. With regards to the letter by the Office of the President, I think obviously it would be better if the answers could be forthcoming earlier than the 16th of March, but and I think maybe the response by yourself to Dr. Koorhof should try to highlight that if it is possible that it is earlier than the 16th, that would be appreciated and would assist our process. But the outer deadline of the 16th, we accept. And then, because it is, as other members have also said, that follow-up questions will most probably be, we will have to ask follow-up questions most probably, and we will have to have enough time allowed for that. With regards to the presentation on the drafting, we welcome that. And yes, Chair, I also agree that it would be good at the onset, when we start the process, to have a, let's call it a workshop or a brief discussion to set the limits and to be on the same page with regards to what our findings should entail and what it can't or may not entail and what it may entail, and also how we should frame our recommendations so that it leads to action, so that it is executable, and that it's not vague and does not lead to any action. Because as other members have also said, people out there, the public want action, and our report should not just be a report that gathers dust. It should lead to real solutions to the problems and actions that are executable and can be taken. So such a discussion at the beginning will be fruitful. Thank you, Chair.
Honorable James.
Thank you, Chair. I'm going to support the input given by Honourable Vessels with regards to the response from the Presidency. It would be appreciated if we could get a response a lot earlier so that we are even able to ask further questions. And then on the report, I'm going to support EFF's proposal that we have a workshop, because even though we have our pillars of investigation and probing to which we should give recommendations on, I think this committee has extended itself beyond which we set out to do. And at this point, before we give any input on what should happen and how it should happen, I think it is important for us to get guidance from the legal team. There are those issues that requires immediate intervention. We will be able to give recommendations on immediate, tangible, actionable change. And then there are also those reforms that won't be able to happen overnight. That's going to take years to implement. So I think for us to start with that workshop, that's a good space. And I'm going to leave it at that. Thanks, Chair.
Ms. Silkstone.
Chairperson.
Hello, who is that?
Honorable Souls, Chair.
Okay, Honorable Souls.
Sorry, Chair, I didn't express our view on the President's submission. The Patriotic Alliance has no problem with the 16th of March. Thank you.
Ms. Silkstone.
Chair, I don't think I have anything to add. I think that some of the questions may well be answered when the evidence leaders, about what is, how we frame things, might be answered when the evidence leaders present a consolidated overview of the evidence. Obviously we're guided by the chair and by the members as to what they would, how they want to carry the process forward. Thank you.
The evidence leaders and the parliamentary legal team.
Sorry, Chair, can I just say? No, it's fine.
Hello, Ms. Silkstone.
Sorry, Chair, I was going to say something earlier, but I think it's been covered, and I'm fine. Thank you very much.
Can we hear from the evidence leaders and the parliamentary legal team?
Chair, this is Adina. Yes, Chair. Can you hear me?
Yes, Mr. Tejana, can we go ahead?
Yes, thanks, Chair. No, Chair, I'll be brief. Chairperson, I think the issue of what Parliament can do, in terms of the Constitution, Chair, I think is clearly spelled out, in the Constitution. And I think primarily there are three key functions which Parliament is mandated to do in terms of the Constitution. And I think the first one, Chair, is that the institution makes laws. And of course, the second one is that the institution facilitates public involvement, in its processes, including in the lawmaking process. And of course, the third one is that Parliament exercises oversight over the executive. And I think the third pillar, Chair, that's where we are in terms of the inquiry that we are doing. So Chairperson, when you talk, and I know that Honorable Nomvara is going to challenge me, when you talk about investigation, Chair, you talk about, if you read, for instance, the relevant rule, which is 227 of the National Assembly, you will see that it talks about, monitoring, to investigate and make recommendations. So that investigation, Chair, is in the context of making recommendations. So the issue, Chair, is that, and I think I've raised this issue before, Chair, even though members chowed me for breakfast the last time I raised it, is that Parliament is not an investigatory body, Chairperson. That function resides elsewhere in the executive, not with us. And that's why I was saying, Chairperson, you can't expect a body like Parliament to make findings of guilt. I mean, we can't, Chair, because we're not empowered even by the Constitution to do so. And I think the issue here fundamentally, Chair, is that we are expected to surface issues, Chair, and having surfaced them, to then make recommendations to the relevant law enforcement agencies to act on these things. So, Chairperson, for now, I'll leave it there and allow counsel to come in and share his own perspective with us. Thanks, Chairperson.
Advocate Aransa.
Chair,
Honorable
I have my hand up. Chair, I just thought that in the interest of time that we park that matter and that we actually have some sort of workshop that will discuss our approach to our report.
Honorable Mathai, may we please have Advocate Aransa commenting on the inputs that members have made.
Thank you, Honorable Chair, honorable members. Parliament has given the Ad Hoc Committee its terms of reference and what it is required to inquire into. Those terms of reference basically are the allegations made by Lieutenant General Mkhwanazi on the 6th of July. So this honorable committee must be guided by the terms of reference. We have, as far as possible, sought to schedule and invite witnesses that could assist this honorable committee in determining, establishing, ascertaining, finding out whether some or all of the allegations made by Lieutenant General Mkhwanazi has been or could be established through this evidence and from the witnesses. It seems to me to be quite logical, and to put it another way, it seems to me illogical if this honorable committee cannot draw its own conclusions from the evidence. The standard of proof in any civil proceeding is usually on a balance of probabilities, and make its findings in relation to those issues that arise from the terms of reference. So, for example, on infiltration and capture, I think in some instances we already have some very clear evidence of that. For example, in relation to IPID, and there are other examples that one could use. I think the National Assembly will expect this honorable committee, given the time that it has spent in interviewing and witnesses and hearing evidence, that they would want to hear what the evidence was, albeit in summary form, and what's come out of the evidence, what the findings are of this committee, and what recommendations this committee will make. The recommendations is obviously limited, given the separation of powers, limited to, albeit very, very important, any remedial action that Parliament should take in terms of, for example, the appointments. We've heard evidence which certainly, in my own respectful view at this stage, clearly demonstrates that there are issues with the appointment of the National Commissioner, Provincial Commissioners, Deputy National Commissioners, and their portfolio.
acts and regulations have been deemed unconstitutional by the Constitutional Court. Having said that, we don't doubt the capacity of the Joint Standing Committee of Intelligence. The concern here would be that while the IGI might have appeared before that committee, we are going to be making findings and recommendations without having additional information that is available to us. So we were going to need some guidance on what if we do a finding or we do a recommendation in the absence of this report, and then it's actually contrary to what has been submitted or presented to the Joint Standing Committee of Intelligence. So that's a reality of this matter as well. Our terms of reference, Chair, also allows us to do an in-camera or take the IGI in camera, though it wouldn't be something that would be our first go-to, because the entire nation is interested in this process, and I think they should be or be able to have the opportunity to see what is also going on behind the scenes. Also, we must also just consider, Chair, and maybe our legal team can look into it, what recourse do we have as Parliament if both the President Ramaphosa and the Minister is either refusing to consult with the IGI, or they are dragging their feet, especially given our looming deadline on us having to conclude this process. So one of the options is that we engage both the President directly, President Ramaphosa directly, and also the Minister directly, rather than going through the former IGI to ask them what's the hold up. I think also we should pay attention to the word on consult rather than the word grant permission. And I think those are two different requirements that the IGI requires. So that's something that we should also consider when we make our decision here. Thank you, Chair.
Chair.
60,000. Hello.
Honorable Malema.
Honorable Malema, good afternoon.
Afternoon, Chair and colleagues. Can I just make a small contribution?
You are allowed to.
I don't think this is a genuine reason why the IGI is not allowed to attend. Firstly, we are investigating, amongst other things, the interference of a minister into issues of the police and so on and so forth. And which means we are investigating the interference of the executive into some of these issues. Now, when you say the AGI must get a permission from a minister, that will mean Minister Mkhumbuzo Ntshavheni, and she's implicated in those properties that we're talking about. And she must give a person a permission to go and talk about how she might be or not be implicated. Because the minister is conflicted, as it were, and therefore not in any position to give a person who might give evidence that demonstrate that actually one of the properties that were purchased wrongly has got a link with the minister. A minister who must give him a permission to come and appear before us. So we cannot allow that. And then the same thing with the president. The president who suspended, who put on special leave a minister who's accused of interfering in the operations of the police instead of firing him. The president might as well be implicated, because we were investigating to what extent does the executive interferes with the operations of the criminal justice system. And therefore, we
we are not called an ad hoc committee for no reason. And it's not like a police committee calling a IG who can actually appear before the committee on intelligence. It's not a normal operation, and therefore we cannot want to behave like we are a special committee which has got a lifespan and which has to deal with more complex matters. We had a head of crime intelligence appearing before us. There was nothing, none whatsoever that was asked which compromised the integrity of the crime intelligence. Nothing. But he was asked questions. He was not asked a name and a surname as suggested by evidence leader. Was not asked that. He was asked serious questions, but they did not interfere with top secret or anything of that nature. Corruption can never be a top secret. Corruption. You cannot classify corruption as top secret. We are investigating corrupt manner in which our institutions have been collapsed. And that has got nothing to do with top secret. Top secret will mean an authorized project that has followed the necessary requirement, and therefore, if spoken to, has got the potential to undermine the integrity of such an investigation or even the institution. There are issues, some of which are in public. The journalists can scrutinize those issues without being arrested, without being told they are undermining an intelligence act. But we can't. The ones that must hold the executive account. Therefore, I find that reason nonsensical and unacceptable. It's not you are covering up corruption. That's what you are doing. And you are using intelligence to cover up corruption. Corruption. That's what you are doing. There's nothing that stops us from calling the IGI to come to us and ask him any question as a professional, as a qualified person who heads that institution. It is well within his right to say, I cannot venture into those other matters because they are of top secret or whatever the reason might be. But you are not going to answer for him. We are not going to answer for him. So we have to find a way to bring a willing IGI to come before this committee. His willingness is a demonstration that he's got something to share with us, which might not be. He knows what is top secret. He knows it better than me and you. He knows which areas never to canvass in public. And therefore, Chair, our proposal is that whatever happens, let the IGI come and then let's discuss issues and let the IGI tell us we cannot go into that space. But the South African public must know that we left no stone unturned. Thanks, Chair.
It seems like the chair got disconnected.
Okay, members, can we get the view of the IFP? Well, so we're still trying to locate the chair.
Please don't forget to come back. We are having network problems as well. Thank you, Chair.
That's noted on us, course. Honorable Mwango. Members, can you hear me?
We can hear you, Acting Chair.
Yes, we can hear you, Honorable Mwango.
Okay, Chair, we are back. We are calling for Honorable Mwango as the next speaker.
Yes, I got kicked out. My gadget would have heated. We've been in the meeting for over 5 hours now. Honorable Mwango. Honorable Sauls.
Chair, I'm a bit confused, and legal can advise. Firstly, my understanding is that the IGI is independent. So, as such, that independence means that he's not supposed to get permission. My understanding is correct. And my limited understanding of the powers that we've been given by the Constitution to call anybody, and this includes the IGI. So the Constitution gives us this right to call anybody. There's no restrictions. Would the Constitution then allow that the provision to call anybody is limited by the IGI having to receive permission? Because that would mean the constitutional powers given to us is now limited and depends on the conclusion of consultation that he had to start in terms of Section 78B of the Intelligence Services Oversight Act. So this is a bit confusing to me. Maybe what the evidence leader should do for us is advise us on using case law. What is the difference between the use of the word after consultation with and in consultation with? Because the way the SC is interpreting the section, he is saying, in my understanding, that because of Section 78B, the committee must first wait for the consultation process required by the section, that IGI must start and he must consult and engage, and then only if that process is concluded, then the decision can be whether he can come before us or not. Is that what the Act is saying? And in order for us to know if that is what the Act is saying, the SC must advise us using case law. What did the courts decide on the interpretation of the words after consultation and in consultation? Because Section 7 says after consultation, which means preserving the independence of the IGI, he must initiate consultation and he must discuss, but he's not required to await agreement or concurrence or permission before he acts. It is discussion. That's after consultation, and that's what the act is using. The act is using after consultation. If it was in consultation, then this now gives veto powers to the other person, that there must be agreement, there must be permission given. But because I'm just a layman, Chair, but I'm committed to ensure that we preserve the integrity of the committee and we emphasize procedure and we implement it correctly. This is why I'm putting this to the committee, not because I know, it's just my reading of the provisions. So my dependency is on the SC to tell us, how does case law, how did the courts define the use of the words after consultation and in consultation? When we have this understanding based on case law, then I think it would make it easier for us to then interpret what Section 7(8)(b) of the Oversight Act is actually saying, read with the provisions of the Constitution that empowers us to call anybody. Thank you, Chair.
Honorable Vessels.
Thank you, Chair. Chair, I agree with previous members that spoke on the fact that we should not be restricted in our constitutional duty, and that the limitations that the Intelligence Oversight Act imposes should not restrict oversight by Parliament. And obviously, as it has been put quite eloquently by the Honourable Malema, crime may never be classified, and we can't allow that. But Chair, as the Honourable Souls also spoke on the interpretation of after consultation and so forth, I think the important part is that what the IGI is telling us is that consultation has not taken place yet. And that is why he can't appear in front of the committee. And a previous member, I can't remember who it was, said that there should maybe be engagement on that issue. And I want to support that. I think, Chair, if yourself, on behalf of the committee, should maybe write to the presidency on this issue to ask for the indulgence of the president, so that consultation do take place, and that there is that this impediment is solved with regards to the appearance of the IG. And I think that is a constructive way forward, because the Act does require the IG to consult, and that consultation has not taken place. And the consultation with the president has not taken place. And let's try to assist so that we do get resolution on that and then take it further. Thank you, Chair.
Honorable James. Advocate Arendse.
Yes, Honorable Chair.
You have heard the inputs of the members. What is your advice on the matter?
I don't know why Honorable Souls needs a legal opinion. He's quite correct in his analysis of what the difference is between in consultation with and after consultation with. After consultation, which is the words used in the Act, requires the Inspector General to advise the President and the relevant minister, whom he has interpreted to mean the Minister of Police, because the subject matter of his report relates to SAPS, that he informs them that I hereby wish to consult with you about this. It obviously involves some kind of a two-way process, but it doesn't require agreement or concurrence from the President and or the relevant minister. And at the end of the day, having conferred with them, he retains the discretion whether or not to give evidence, like in this case, and provided, of course, all the other hurdles are overcome, that it doesn't concern restricted or confidential information that may compromise state or government secrets, etc. So that would be the answer to what those two words mean, Honorable Chair.
The Chair.
Hello.
Chairperson, may I?
Honorable Sals.
Yes, Chair. So if that's the understanding, then that would mean that nothing stops the committee from having the IGI appear. Because it means that the law now protects our powers to ensure that no one from the executive can stop us from exercising our powers by withholding a response to consultation that's required by Section 7. Because his appearing before us is not dependent on the outcome of consultation. Thank you, Chair.
Chair, sorry, I know there's
with that explanation that you have made, Senior Counsel, what does it mean to the letters that have been presented before us? What do they mean?
Chair.
Sorry, Chair. May I just, before I answer that question, just a previous point made, I think, by Honorable Matthys. Yes, the Constitution does provide that Parliament exercises oversight, but Parliament has also devised a whole legal architecture which does require or which does provide for that oversight. And the argument will be or might be that oversight is done through the Intelligence Committee and the Joint Committee on Intelligence. And that informs the approach which is apparent from the letter written by the chair of the Joint Intelligence Committee to the IGI, that he is accountable to that committee. So it's not a straightforward answer. Ideally, if that consultation, even if the IGI after the consultation decides, no, I'm still going to appear, it would have been helpful if that could take place between the president or the presidency and the minister of police, because so that he can also inform them of what evidence he intends to give to the committee. And just on a practical level, that has not yet taken place. Thank you, Chair.
Yeah, I hear your explanation. I'm saying that there are letters that have been put before us here from the IG, from the former IGI or the suspended IGI.
Well, sorry, Chair, the letters, the one from the Minister of Police says that he has sought legal advice, and as we speak, we don't know whether that advice has been given to him or not. He says in his letter that the request by the IGI for the reports given to him are not unreasonable. So that advice must still be given to the Minister of Police. As far as the as far as the letter from the chair of the Joint Committee on Intelligence is concerned, they are opposed to him appearing before the Ad Hoc Committee, it seems, from their letter. Thank you, Chair.
Yeah, but what is the proposal that is being put before the committee regarding the matter? How does the committee move forward on this matter?
I think maybe as soon as possible, still today, I think we should we should respond to these letters, and indicate, because it seems to be pretty clear from the majority of committee members that they want the IGI to appear. So it may not, it will obviously not going to be tomorrow as it was originally scheduled, but will have to be.
Who do we write to?
To the various entities that have written to us, the copies that are attached to the IGI's letter to us.
Okay.
We have to inquire from the Minister of Police this opinion that you said you're obtaining. Can we please have a copy, or when can we get a copy? Because that opinion may well concur with the IGI's view that he be allowed to give evidence. And that will help. Thank you.
Let me hear from the members, what do they make of your proposal that we must write to the respective institutions and hear whether they are playing an enabling role to assist the IGI to eventually appear before. Because indeed there is national legislation that regulates the conditions of service of any office bearer. So the Constitution may say that Parliament can summon every person before it. But you'll find that there is also national legislation that says, like with intelligence officials, where they must first get approval before they appear. So we have to navigate that.
Oh, I tried it. Yeah.
Properly. Yes. ANC.
Thank you
Honorable
very much,
Mola, in case I got
Chairperson.
cut.
Let me, from the onset, reiterate our Chair. Can you hear me? Chairperson, can you hear me? Honorable members, can you hear me? So
We can hear you. We can hear you, Honorable Sangwan.
Okay, thank you so much. I wanted to reiterate the position of the
Honorable Mola.
ANC, which is aligned to the position of all members in this committee, that we want the IGI to appear. We had thought that that was not going to happen, but given the fact that